Gentleman yields back. I now recognize myself for 5 minutes of questions. And I just want to say, since the beginning of Congress, we have been approached by countless stakeholders about the need to reauthorize CISA 2015. In fact, we have 8 statements that we will be submitting for the record, one of which has 52 organizations as signatories. So I would like to, without objections, add these to the record. So done. Okay, wonderful. So ordered, yeah. That's great. I can do this by myself. Wonderful. You all have said reauth has to happen, so I'm not even going to start with that question. Everybody's saying that it has to happen. And it sounds like clean reauth is, everybody thinks, is the best way to do it, just to get it, make sure it's done. What would happen if this did not get reauthorized? You can all jump in. I want to hear from everybody. I feel like we need to get on the record why it's so important this has to be reauthorized. What would happen if it wasn't reauthorized? Want to start, Mr. Miller?
Thank you for the question, Chairman. I think if it was not reauthorized, there would be an immediate chilling effect, at least for some organizations, on their willingness and ability to share, because those express authorizations in the bill and those attendant liability protections would go away. This is not to say that information sharing itself would completely stop. Information sharing did occur before CISA 15, but a lot more of it is occurring after CISA 15, and in particular, automated sharing at scale. Again, as I understand it, as a lawyer, not as a cybersecurity operator, didn't really exist in nearly the same way that it does today. And the bill should be credited for that. I personally think it's an open question, given what exactly the fate of, for instance, the automated indicator sharing program at CISA would be if the bill went away, because their authorization to run it would go away. It doesn't mean they would necessarily stop doing it. We don't have Homeland authorizations every year, as you know, but it would put things into question. And so I think this would undermine a lot of certainty across industry and government, and thus undermine the certainty that we have with the trusted sharing partnerships that have been built since CISA 15.
All right. Mr. Ronaldo?
You're taking the decision from the CISO to the General Counsel's office, and that is going to slow everything.
Oh, yes. Us attorneys are the worst.
I didn't say that.
I can say it, it's okay. Mr. Shimek?
Yeah, reiterate that. It's basically firms would immediately hesitate. There'd be uncertainty in what would be shared. Things would slow down. The other thing is you would very much be locking out the small and medium-sized businesses and companies and vendors. Like, this would be a big firm-only play, because we would be the only ones willing to try it, willing to evaluate it. And then you'd also, I think, you'd start to see what we saw previously, which is every firm building bilateral CRADAs with the U.S. government instead of going through this framework.
It's a very key point. Thank you for making that. Ms. Keene?
Just to reaffirm everything that everyone else has said, but you're right, there was information sharing before 2015. We did have it, but it was picking up the phone and kind of chatting behind closed doors. And that's going to hinder, from both a proactive and a reactive, cyber defense strategy if we don't have those safe harbors. And to my fellow committee's point, it puts it in the hands of the lawyers. And the reality is that with AI coming in, with what we're seeing with the rapid spread of threat, we don't have time for it to go to the lawyers at this point. We have to be able to share information quickly.
Yeah, the slower we are, the more exposed we are.
100%.
That information sharing is very important. Mr. Shimek, I want to ask you, you work at, you've worked with CIFMA for a while, and I wanted to know if you could specifically share some information with, or some anecdotal information about how your companies or other companies you've worked with have shared information under this law.
Sure. So what we'll use this for typically is we will provide the information via AIS. So we have that path of sharing the information with DHS when we need to. We also use other mechanisms, phone calls, email. DHS provides multiple ways for us to submit information, so it provides maximum flexibility for firms to go do that. But then it also enables us to go peer-to-peer. There is probably not a day that goes by that I'm not talking to a peer CISO out there on some issue that's going on, either emerging or on an active threat that we're dealing with. And this just provides us that flexibility to make sure that anything we're sharing, we're protected. We're doing it under the best intentions. And so it really allows us to, as we say in financial services, this is a non-competitive topic for us. We want to make sure that the entire system is protected, because if there's an attack against one bank, it calls into question the entire system. And financial services, more than anything else, is built on trust.
I appreciate that. My time has expired. We're going to start a second round of questioning, and I'm going to recognize for a second round of questioning the gentleman from Florida, Mr. Jimenez. 5 minutes.